less than a year after upholding the President Obama's Health Care Act, and weeks after hearing arguments in affirmative action and the Voting Rights Act, the Supreme Court takes on another blockbuster case testing legal restrictions on same-sex marriage. On Tuesday, the justices are going to hear a challenge to Proposition 8, a voter initiative that California passed in 2008 that removed the right to same-sex marriage from the state constitution. Lower courts have struck that proposition down. The justices will consider whether or not they were right, and they have several ways to consider the case. They can dismiss the case on very simple procedural grounds without leaving any nationwide precedent regarding gay marriage. Or they can go all the way and declare that the Constitution's equal protection provision and due process clause require recognition of same-sex marriage everywhere. They have several ways in between in which they can strike down Proposition 8, or they can rule that the voters legitimately passed it in the first place. On Wednesday, the Supreme Court will consider the Defense of Marriage Act. That's a 1996 federal law that prohibits the federal government from recognizing same-sex marriages or giving federal benefits, including tax deductions or retirement or spousal benefits, to same-sex spouses who today can be legally married in 9 states and the District of Columbia. The issues in that case are somewhat narrower than the Proposition 8 case, and they involve not only gay rights but also states' rights, because states traditionally have defined family law under the American system. Both cases have an unusual array of people on either side. On Tuesday's case involving Proposition 8, the challengers, 2 gay couples from California, are represented by Ted Olson, President Bush's former Solicitor General and the winning lawyer in the 2000 election case Bush v. Gore, and his opponent in that 2000 case, David Boies, a Democratic lawyer who teamed up with his conservative opponent to represent the gay marriage cause. On Wednesday, the Obama administration will argue that the Defense of Marriage Act, a federal law, actually is unconstitutional, and they will be suggesting that the Supreme Court strike down its provisions requiring denial of benefits to same-sex spouses. Instead, the U.S. House of Representatives, which is controlled by Republicans, has stepped in to defend the Defense of Marriage Act, and it has hired a former Republican Solicitor General, Paul Clement, to speak up for that law and urge the justices to uphold it. Lower courts have held that the Defense of Marriage Act unconstitutionally discriminates against same-sex spouses. The answers to these questions probably will not come before July, which is when the justices will rise for the summer, leaving us with a tremendous amount to think about if this year is like the last several. For the Wall Street Journal, this is Jess Braven.